Hello everyone, welcome back to our channel Legal Nexus. In previous video, we discussed the contract of agency. Today, we'll continue from there and move deeper into rights and duties of agent. This part will help you understand the concept more clearly with practical examples and simple explanation. So, stay tuned till the end as we are break it down step by step. Right of an agent. An agent has the following five rights: right to retain, right to remunerate, right to lien on principal's property, right to indemnify, right to compensate. The right of retain means an agent has the right to retain any remuneration or expenses incurred by him while conducting the principal's business. Right to remuneration. An agent, when he has wholly carried out the business of the agency, has the right to be remunerated of any expenses suffered by him while conducting the business. The agent has the right to hold any movable or immovable property of the principals until his due remuneration is paid to him by the principal. This statement refers the right of lien property of principals, right to be indemnified. The agent has the right to be indemnified against all the lawful acts done by him during the course of conducting the principal's business. Right to compensate. The agent has the right to be compensated for any injury or loss suffered by him due to the lack of skill and competency of the principal. Duties of agent. Duty to execute the mandate. Section 211 of the Indian Contract Act 1872 bounds an agent to conduct the business of his principal according to the principal's direction or in the principal's absence according to the custom of trade. In Panalal versus Mohanlal 1950, the Supreme Court held that the agent liable to compensate the principal if the principal told the agent to get the goods insured. The agent charged the premium from the principal but never got the insurance. Duty to act with care and skill. Section 212 of the Indian Contract Act 1872 covers another role of the agent. This law requires an agent to conduct agency business with due care and caution. In Jai Bharati Corporation versus P.N. Rajshekhar Nada, 1991, the Supreme Court said that where the agent misforms the principal, the loss occur because of his misconduct. He is liable to the principal. Duty not to deal on his account. If the principal wishes to deal on his behalf in the agency's business, the agent must disclose all material circumstances that have come to his knowledge. He must also get consent from the principal. Non-observance of this duty may lead to, under Section 215 of the Contract Act, the principal may repudiate the transaction on his claim and losses. Under Section 260 of the Contract Act, the principal may claim from the agent any benefit which may have resulted in him from the transaction. Duty not to delegate his authority. An agent must not delegate his authority to an sub-agent. Authority of an agent as per Contract of Agency under Indian Contract Act. Express and implied. Express authority. According to Section 187 of the authority is said to be express when it is given by word spoken or written. Implied authority. According to Section 187, authority is said to be implied when it is to be inferred from the facts and circumstances of the case. In carrying out the work of principal, the agent can take any legal action, that is, the agent can do any lawful thing necessary to carry out the work of the principal. Agency between husband and wife. Generally, There exists no agency between a husband and wife except in cases where it is expressly or impliedly been sanctioned that either of them would do certain acts or transactions as the agent of the other. For example, a relationship of agency can come to existence between two through four or a contract, appointment, ratification. A husband is responsible for necessaries to his wife when they are living apart due to the husband's fault. This results in an agency of necessity where the wife can use her husband's credit for what is necessary for her to live. But in cases where they are separated because of wife's own whims or faults for no just reason, the husband is not liable for the wife's necessaries. Different modes of creation of agency. An agency may be created express agreement, implied agreement, ratification, and operation of law. Agency by express agreement. An express agency is created when a principal appoints an agent either by words of mouth or by an agreement in writing. For example, A execute power of attorney on a stamped paper by which he appoints B as his agent to sell immovable property. It is an express agency in writing. Agency by implied or implication agency. Implied agency arises from the contract, situation, or relationship of parties. It can be inferred from the circumstances of the case. To illustrate implied agency, in the name of P for the purpose of the shop and paying for them out of P's fund, with P's knowledge, A has an implied authority from P to order goods from T in the name of P for the purpose of P's shop. A is an agent of P because of implied agency. Implied agency may be of three types: agency by estoppel, agency by holding out, and agency by necessity. Agency by estoppel. Estoppel is a rule of evidence. If a person by his conduct of by words spoken or written induce another person to believe that a certain person is his agent, he is estopped from denying subsequently the act of agency. Section 237 apply if the following conditions are satisfied. Agent should have incurred liability to third person for his principal. The agent should not have authority. The principal by his words or conduct would have incurred the third person to believe that agent has authority. If all the above conditions are satisfied, an agency by estoppel is created and the principal is bound by obligation or liability incurred by the agent. The third, implied agency. Agency by holding out. Agency by holding out is a branch of agency by estoppel. In case of agency by holding out, the prior positive act on the part of the principal is necessary to establish agency subsequent. Agency by necessity. Because of necessity, the law conferred an authority on a person to act as an agent for another without the consent for that other person. Such an authority or agency is called agency by necessity. Agency by ratification. A person may act on behalf of another without his knowledge or consent. For example, A may act as B's agent through he has no prior authority from B. In such case, B may subsequently either accept the act of A or reject it. If he accepts the act of A done without his consent, he is said to have ratified the act, and it is placed the parties in exactly the same position in which they would have been if A had B's authority at the time he made the contract. Agency by operation of law. Sometimes an agency arises by operation of law. When a company is first formed, its promoters are its agents by operation of law. A partner is the agent to the firm for the purpose of the business of the firm, and the act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. In all these cases, agency is implied by operation of law. To sum up, the contract of agency is a legal relationship where the agent acts on behalf of the principal and binds the principal in dealings with third parties. It plays a crucial role in business and commercial transactions by making representation and delegation possible. Understanding the right, duties, and authority of both the agent and principal is essential for avoiding disputes and ensuring smooth transaction. I hope this video helped you get a clear idea of the concept. Don't forget to like, share, and subscribe for more legal insights.